Appeal in the matter of VTB Bank and JPMorgan Chase Bank and others.
Yes, Mr. Bennett.
Good morning, my lord. In this matter, I appear with the lender Mr. Jones for the Appellant Bank, and the lender is Ms. Hutton and Mr. Lynch appear for the Respondent, amongst other things, Bank. Your lordships will know that in a sense, the most important aspect of this appeal is the correct legal test for the vexatious and oppressive ground for granting an anti-suit injunction, which is, as the judge below indicated, something on which there is a lack of authority at this level. But in order, before I get there, although it comes as grounds 1 and 2 in my skeleton,
And you have to succeed on those grounds, don't you?
I'm so sorry?
You have to succeed on those grounds.
I have to succeed on that ground, yes. But it's relevant to look at ground 3 first, because ground 3 gives us a background to it, against which to test that. Now, what I want to do first is to look at the particular contracts in order to see why it is that we say that those who are not parties to those contracts can't rely on them. And if we can go in the core bundle, please, first to page 223, which is the Unallocated Metals Agreement. And again, I need to just draw attention to the key provisions.
Yeah.
I'm not going to.
I should have said that we have, of course, read the judgment and the
Of course. So I'm taking all that as read,
Yes.
just going to the core points.
223.
If we
Yeah.
look at the Unallocated Metals Agreement, starting at page 223, and go, first of all, the introduction, open and maintain for you an allocated account, provide other services to you in connection with the unallocated account. This agreement sets out the terms under which we provide these services to you and the arrangement which will apply in connection with those services. Fairly straightforward. Page 229, paragraph 13, clause 13. 13.2, rights under the agreement in addition to and independent of any other rights which we may have at any time in relation to the unallocated accounts, and any lien or other rights we may have set off, etc. 13.3, assignment, for the benefit of and binding upon us both and our respective successors and assigns. You may not assign, transfer, or encumber, or purport to assign, transfer, or encumber your right, title, or interest in relation to any unallocated account, unless we otherwise agree in writing. And then 13.6 is the entire agreement clause. And over the page, arbitration clause. Any dispute arising out of or in connection with this agreement, including any question regarding the existence, validity, or termination, is referred to arbitration. Now, the learned judge held, despite our submissions at first instance, that was sufficient to include within it the claims which are made by my clients in Russia, although they were tortious claims arising out of, essentially, out of subsidiary liability and sanctions issues. So that is sufficient, we accept for these purposes, to provide protection to JPMorgan Chase, which was the contractual party to that agreement. The client agreement, which is on the next page 231, which is between JPMorgan Securities and the bank, so that's the other set of proceedings launched against my client. has in it at page 233 the introduction, the agreement together with schedules, sets out the terms upon which JPMSL agrees to open a futures and options account for the specific purposes, execution and clearing of exchange listed or OTC cleared products. And then next paragraph, where the client enters into terms of business with JPMSL, this agreement, rather than the terms of business, shall govern the client's relationship with JPMSL for the execution and or clearing of exchange listed or OTC cleared products and options accounts. However, the terms of business shall continue to govern all other investment business with JPMSL as defined by FISMA. In the event of any conflict between the agreement and terms of business, this agreement shall prevail. So one sees some hierarchy there. Then under affiliates, any one of, it's very wide. You see there, any of their subsidiaries, officers, directors, employees, any other entity which it says is an affiliate. Then I think we can go directly to, well, the definition of affiliates is later on that page. Any one or more of JPM, any subsidiary, etc.
Yeah.
Go on to page 247. And the dispute resolution clause, and I'm not going to argue the clause 35 point. Judges dealt with that. So the parties agree any dispute arising out of or connected with this agreement, including a dispute as to its validity or existence, the agreement in this clause, or any non-contractual obligations arising out of or relating to this agreement, shall be resolved by arbitration with 3 arbitrators. So again, we have the reference to any non-contractual obligations arising out of or relating to it. And again, the learned judge found, and we don't contest for these purposes, that the dispute in Russia is sufficiently within that clause to protect the contractual counterparty to this agreement, JPMorgan Securities, from a claim contractually. So in essence, we're not dealing with those two, except on my ground 4, when it comes back in again. What the learned judge, having correctly rejected the notion that where you have the clauses which we've seen, entire agreement clause, limited clause, and no third party being able to rely upon it, we're driven to the terms agreement, which is the basis on which the learned judge found, and learned friend still asserts, that all of the other defendants to the claim, apart from what I'm going to call JPMorgan Russia, because I can't get my head around all these names, can shelter as of right. And I just want to look at, because it's important in context, just one aspect of the 2011 terms, which were the terms which preceded the 2017 terms of business. That's at tab 24 of page 315. And the only bit of it I want to look at is clause 30, which is at page 328. And this has much the same wording as we'll find in the 2017 terms. But having applied English law under 30.1, to any agreement or transaction executed in connection with the services provided to you under these terms by JPMorgan. It goes on to deal with jurisdiction. And in 2011, the jurisdiction clause was different because it was a provision at 30.3. English courts have exclusive jurisdiction to settle any dispute, difference, or other question arising in any way out of these terms, any agreement which terms relate, and so on. But it provides also, so prima facie, English law, English jurisdiction of the English courts. And at the end of that, you and where applicable your principal or principles irrevocably submit to the jurisdiction of the English courts, agree the English courts are the most appropriate and convenient courts to settle any dispute. Then there's a provision under 30.3, which I just ask your lordship to look at in a second, which effectively allows either party to opt for arbitration, either before proceedings are issued or immediately after proceedings are issued, but before service of any defence. Again, on page 329, the right to third parties. Any affiliate may enforce and rely on any provision of these terms, conferring a benefit on it to the same extent as if it were party to these terms. Save as aforesaid, no rights under the Contracts Rights of Third Parties Act. So the relevance of that is that until the 2017 terms were, as the judge found, on the evidence, or lack of it, served upon my clients, these terms prevailed, and insofar as the terms applied, they were provisions for English court jurisdiction rather than arbitration. Now, that changed in 2017, it's important to see how it changed. And if we look at page 331, there are various other reasons for the change, but paragraph 1 on page 331, we're updating our terms in accordance with clause 26 of the agreement to incorporate key regulatory requirements. And then at 3, these terms and supplements enclosed will supersede and replace from the effective date any earlier version of the terms of business received from JPMorgan, but they will not supersede or replace any product contract, for example, any ISDA agreement, as defined under clause 1.3 of the terms. So what we have here is, if you like, a unilateral notice from JPMorgan, which imposed fresh and different terms, as we'll see in a moment, they are imposed not by my client signing an agreement to confirm that he's content with those terms, but simply by notice and by not doing anything about it, but continuing with the relationship. Then we can have a look, please, at the terms themselves. They start at 338, but I can pick it up at 339. We see they govern all, this clause 1, all designated investment business as defined under the FCA handbook and PRA handbook in relation to other traded products and any other service which is provided to or for you or transacted with or for you by any one or more of the following companies. And then some of them are listed, of which one is a defendant, and each of these companies shall be severally and not jointly liable for their respective acts and omissions under these terms. Then affiliates, again, broadly worded, direct or indirect subsidiaries of JPMorgan, direct or indirect subsidiaries of their direct or indirect holding companies, associated persons, whether or not any, whether it exists at the date on which you accept these terms, or is established or acquired after that date. And then 1.2, they constitute a legally binding contract which you accept for yourself and on behalf of any principal principals on whose behalf you're acting by giving us instructions to deal or accepting services from us after our dispatch of the terms to you.
Yeah, so that's acceptance by conduct.
I'm sorry?
Acceptance by conduct.
Yes. Acceptance by conduct from notice against a situation where, as we've seen from the other agreements we've looked at, there are clear agreements signed by both parties, which both parties will obviously have been aware of and whose terms they will have been aware of. And here we have this acceptance by conduct imposing it on them. And that's relevant when you come to look at how you construe it in my submission. And then we see at 1.3, these terms supersede any terms of business for investment business, including any global institution connectivity edition, any Asian edition, any American edition that may have been previously sent to you collectively, or as may have been amended or received from you, transactions entered into or services received under any terms of business which is superseded shall be deemed with effect from your acceptance of these terms as transactions entered into or services received under these terms. Okay, without limiting the application of these terms to transactions entered into or deemed to be entered into these terms, etc. These terms are without prejudice to, shall not supersede or amend any other contracts entered into by you, where applicable, your principals and JPMorgan, relating to specific types of product, services, or transactions, including but not limited to financial instruments under the recast, market in financial instruments, in the event of any conflict between any product contract and these terms, the provisions of the product contracts shall prevail. Now, just to look at it, and then we can leave the document and start getting to the meat of it, page 358. Rights of third parties, paragraph 35. Any affiliate may enforce and rely on any provision of these terms, conferring a benefit on it, to the same extent as if it were a party to these terms or any transactions thereunder, save as aforesaid, a party who is not a party to these terms has no right, under the Contracts Rights of Third Parties Act, to enforce any provision of these terms. So where this leaves us is that because the defendant, I can't think what it is, who is a party to the terms, relies on it, and the other parties, the other defendants, apart from Russia, seek to rely on it by being joined, they seek to rely as affiliates under clause 35 on the terms as requiring arbitration.
Yeah, that's clause 32 too, was the arbitration clause.
Yes, I'm sorry, I passed over that. English law, arbitration, again, fairly standard language. If one just pauses there to consider the position, we have two defendants, signatories to the different client agreement and the unallocated metals agreement, who have rights to arbitrate as the judge found, by virtue of those agreements. And the reason they have is because the judge held that these claims, which are made against all the defendants, are sufficiently related to those contracts that the arbitration clause in those contracts bites. So, assuming that all of the defendants, apart from Russia, are entitled to rely on the terms, either because they're signatories to the terms or because they are affiliates, then one asks the question, what are they doing relying on those terms as a defense to my client's tortious claims in Russia? And the problem for the respondents in our submission is that when you look at the terms and you go back to clause 1.3 on page 339, which provides that where there is another specific contract which is relevant, so again, where it shall not supersede any other contract, and where there's a conflict, the provisions of the product contract shall prevail. If one accepts, as the judge found, that all of these claims fell within the reach of the specific product contracts which we've looked at, then it is, in my submission, impossible to conclude that the claims against the non-contracting parties to the specific contracts who are relying on the terms can in fact say clause 1.3 doesn't apply, because if the claims are, as the judge has found, claims in connection with those specific product contracts, then where there is a conflict between the product contracts and the terms agreement, the product contracts prevail.
What's the test of conflict?
I'm sorry?
What's the test of conflict?
The test on...
Of conflict. You say where there's a conflict between the terms. What test are you applying to decide whether or not there is a conflict?
The conflict I'm applying is that, as the judge found, the terms of those contracts, the exclusion of the 99 Act specifically in one of them, the specific provisions that the contracts are between these parties and these parties only, is such that, as the judge again found, those same defendants trying to rely on the terms cannot rely on the provisions of the specific contracts. And if they can't rely on the provisions of the specific contracts, but the claims are in respect of or arise out of the specific contracts, then clause 1.3 says the terms of the specific contracts apply. And if you can't get out of the specific contracts a provision that enables these respondents to claim arbitration under the contracts, then where there is a conflict because under these terms they could, why would you exclude the contracts and say, well, if VTB wants to sue the two contracting parties, they're stuck with the terms of the specific contracts. But if they want to sue these others, in relation to what the judge has now found as matters arising out of those specific contracts, those others can also say that we can't sue them, we have to arbitrate against them because of the terms, when the terms themselves accept that they are subservient to the main contracts.
So the conflict that you rely on is a conflict between the product contracts excluding third-party rights and the terms which purport to include third-party rights.
Yes, exactly that. And what one then has to say, what is it about these terms which enables these defendants, when they can't rely on the specific contracts which have been found to be the contracts to which these claims relate, which enables them to rely on the terms. And there is that conflict, first of all. Secondly, there is the fact that these terms are clearly intended to apply to dealings which are outside and different from the specific contracts. Now, if I had won on my first point, and the learned judge had accepted that the wording of the specific contracts was not sufficiently wide to capture these claims, and therefore that nobody could rely on the contract, on the arbitration provisions within the specific contracts, then of course the conflict wouldn't arise. And one would simply be looking at these terms and asking the question, do these terms in fact cover the sort of claims which are being made in Russia? When one is looking at this, at a provision where the first point is you can't sue them because the contracts, specific contracts govern them, and the specific contracts require arbitration. These terms, which on day one provided for litigation and then day two provide for arbitration, are somehow said to provide something which prevails against the provisions of the contracts which they rely on for the purposes of their first two defendants, and adds some additional protection, not for other terms, not for other dealings between them, which I accept would be bound by the terms of business, but by the very contracts which are excluded by 1.3.
Well, I understand that conflict, but what is the significance of the difference for this purpose between an arbitration clause and an exclusive jurisdiction clause?
For these purposes, the arbitration clause, in effect, is a requirement to arbitrate. An exclusive jurisdiction clause has less weight, but in my submission, both are caught by this. So, my Lord, what we say, and I'll deal with whatever my learned friend has to say about implied terms. At this point, before we get to the vexatious limb, which I'm going to turn to in a moment, we get the provision that first two respondents, which are parties to the contractual agreements, can rely on them, So if we want to go against them, we have to arbitrate them, subject to the discretion of the court, ground 4. The remaining defendants, apart from Russia, can rely on the terms agreement if your lordship so find, despite my arguments. But Russia, which has not, well, Russia bounced and bounced for all sorts of reasons, but Russia originally joined the claim by way of amendment and then abandoned the claim. So Russia does not seek as an unnamed affiliate, so it's not a party to the terms agreement, it is an affiliate. It would have been permitted, if I'm wrong about the other defendants, to rely on clause 35 to enforce and rely on any provision of the terms, conferring a benefit on them. And of course, one has to consider is the right to arbitrate a benefit or not. But Russia can't do that. So Russia is in unless it's excluded on the vexatious ground. And it is important when one looks not at rights, but at whether a claim is vexatious, to note that this is not a case where JPMorgan entities want to dispute issues between them as to whether or not they can be caught by a Russian law provision by arbitration. They don't want to at all. They haven't sought a stay to arbitration. They simply said, if you want to bring the claim, you would have to arbitrate. We're not going to arbitrate. So this is, in effect,
Well, that's a fairly well recognised position in relation to.
I'm so sorry.
That's a fairly well recognised position for a party who has the benefits of an arbitration clause.
Yeah.
It's not simply the right to arbitrate, but it's the right not to be sued otherwise than by. So I'm not sure where that point goes.
I accept that as a general proposition, but when you're actually coming to look at questions of what falls within vexatious, it is, in my submission, relevant to note that this is not being used as my preferred forum clause, but as effectively a prohibition clause.
I must say I don't follow that at all. Your clients say to the JPM companies, you owe us money, or gold or silver. And the JPM companies say, well, if that's what you say, come and arbitrate.
They do say that in circumstances where we all know that because of political measures introduced and given statutory and regulatory force, the answer to that is, well, you can't have it.
Well, exactly the converse applies in Russia, doesn't it?
I'm sorry, sir?
The converse applies in Russia.
Yes, the converse does apply in Russia, and one has to just bear that in mind. Let me turn, if I may, to the other and more interesting elements, which is the grounds 1 and 2, and we deal with this in our skeleton argument at page 13, bundle page 36. And we accept that the learned judge set out the law correctly, and if we can just look at that, well, away lordships will have looked carefully at the judgment, so I'm not going to take you line by line through it as you will expect. But if we go to the judgment starting at paragraph 144, which is page 101 of the core bundle. This comes essentially from Lord Justice Mayles in SAS Institute. And I'm not going to take your lordships to it unless you want me to, because you'll be familiar with that. Basic principle, the jurisdiction will be exercised when the ends of justice require it. Establish categories of case where an injunction may be appropriate, which may overlap. Include cases where an injunction is necessary to protect the jurisdiction of the English court. Cases where the pursuit of foreign proceedings is regarded as vexatious or oppressive. The jurisdiction is not confined to those categories, must be applied flexibly. Great caution must be exercised before such an injunction is granted, or at any rate where it's not sought to enforce an arbitration or exclusive jurisdiction because of the requirements of comity. It's a comity point, which in my submission is important here. When an anti-suit injunction is sought on grounds which don't involve a breach of contract, comity, telling against interference with the process of a foreign court, will always require careful consideration. And comity requires an order of anti-suit injunction to be granted. The English court must have a sufficient interest in the matter in question. It refers to the natural forum and protect the jurisdiction. The existence of sufficient interest will generally be self-evident. He then makes the point that the category is not closed. In 146, even in case in which injunctive relief is not sought on a contractual or quasi-contractual basis, and this is the hypothesis here when we're dealing with Russia, and if I'm successful on my ground 3 arguments, the fact that foreign proceedings involve the circumvention of an agreement with arbitration with an English seat or an English EJC can itself be relevant in determining whether the commencement and pursuit of the foreign proceedings is vexatious and oppressive, as well as establishing the necessary sufficient interest of the English court to act. Now, just pausing there, it is necessary in our case to distinguish between what will be the finding if I fail on ground 3, that the claim will circumvent the arbitration clauses on which the defendants, apart from Russia, are entitled to rely. This does not assist in the case of Russia, because as the judge found, Russia is not seeking to rely on an agreement for arbitration with an English seat. They're simply not participating in that. So far as they're concerned, that is not a ground on which one can say that there is vexatious and oppressive conduct here.
Why isn't it? Why aren't you seeking to circumvent?
I'm sorry?
Why are you not seeking to circumvent an arbitration clause by suing not the party with the protection of the arbitration clause, but one of their associated companies for the matter which would have been subject to the arbitration clause if it was pursued against the contracting party?
Because I'm suing them under a Russian law provision which imposes a separate liability in circumstances where also the terms agreement itself expressly refers to liability being several rather than joint. So the fact that other parties would be able to mount a defense based on exclusive jurisdiction and the arbitration clause does not mean that Russia could. You have to look at the claim against Russia as a freestanding claim under Russian law, which nobody is suggesting the claim doesn't exist under Russian law. Nobody is suggesting that the Russian company as a Russian entity in Russia can't be sued by a Russian company because of the arbitration clauses.
But the very purpose of the Russian legislation is to circumvent the fact that these obligations are governed by contractual obligations, are governed by English law, and subject to jurisdiction clauses or arbitration clauses.
Yes.
And the Russian legislation is designed to enable Russian parties to sue in Russia by creating a claim against associated companies.
Yes.
So the whole scheme is designed to circumvent the arbitration clauses, isn't it?
Yes, but if I'm sitting here or standing here before a Russian court, what I would be saying is the entirety of the English legislation is aimed at circumventing the proper enforcement of contractual and tortious liability.
That would be the argument for anti-suit injunctions in Russia.
Yes.
But we're not looking at anti-suit injunctions in Russia, we're looking at anti-suit injunctions here. And yet the Russian court would grant them, but we shouldn't.
Well, if one just looks at that and says, what happens if if you're dealing here with an entity which has a Russian subsidiary, which is in Russia, pursuant to Russian law, and where there is money in England, and with an English subsidiary, and the English subsidiary doesn't want to follow Russian law and pay because it wants to rely on the sanctions legislation in this jurisdiction. Is it to be said that that English subsidiary, which is subject to a Russian jurisdiction, exclusive jurisdiction clause, and Russian provisions, even a Russian arbitration clause, is prevented from defending in England and asserting in England a right to withhold money? Or would the English court, faced with that, say, well, I'm sorry, you've got a Russian arbitration clause, and you've got a Russian exclusive jurisdiction clause, and Russian law, and I'm afraid you're going to have to pay. The answer to that, of course, is no, because the English court would then say, well, no, this is in England. And in England, our sanctions legislation trumps Russian legislation, and we're not going to enforce it. So, and if you get an anti-suit injunction in Russia which says you must not come to England and say you're not liable, and you must not say I can't move the money. We're dealing here with matters which are not the political aspects of sanctions, which I fully understand. We're dealing with a situation where both sides are imposing rules which are not related to the commercial contractual relationship between the parties. And they're trying, in effect, to each side to escape their consequences. And what I'm saying is, when you have a Russian company, what is it that makes it inappropriate for a claim against a Russian entity to be pursued in Russia when that Russian entity is not entitled to rely on an arbitration clause? The answer I hear coming from the bench is, well, it's just a way of getting money out of the business, the JPMorgan business, through an entity which is in Russia and which can't rely on the arbitration clause. So shouldn't we protect that with on the vexatious ground? Well, the answer to that is these are under Russian law separate claims made against each separate entity. And the fact that the other entities may have defences doesn't mean that Russian law doesn't have a proper claim against JPM Russia, which should be recognised and, in my submission, should not be frustrated without very careful consideration of the authorities. So, it has, and the authorities bundles divide at the, interesting bit. So we need to look at volume 1, tab 13. Perhaps since we're just here, I can ask you to remind yourselves at tab 12 in BNP Paribas.
Sorry, we're looking at tab 12 now.
Yeah, I'm sorry, yes, can we go close to it?
Yeah.
Lord Justice Hamblin was saying it's page 295, paragraph 68. So, having summarised the guidance, he summarises the approach. Where the parties' overall contractual arrangements contain two competing jurisdiction clauses, the starting point is a jurisdiction clause in one contract was probably not intended to capture disputes more naturally seen as arising under a related contract. So I say here the terms notice, terms of agreement as elevated by conduct is not intending to capture disputes more naturally seen as arising under the two specific contracts, and it says so expressly. Broad, purposive and commercially minded approach to be followed. Where the jurisdiction clause is a part of a series of agreements, they should be interpreted in the light of the transaction as a whole, taking into account the overall scheme of the agreements and reading sentences and phrases in the context of their overall scheme. Recognise sensible business people unlikely to intend similar claims should be the subject of inconsistent jurisdiction clauses. So you would start on the basis that each deals exclusively with its own subject matter and not overlapping. And then 6 over the page, language and surrounding circumstances may, however, make it clear that the dispute falls within the ambit of both clauses. In that event, the result may be either clause can apply rather than one clause exclusive of others. Now, that really, in my submission, emphasises the point that I was seeking to make earlier, that where you have specific contract agreements which do cover the claim and which are expressly stated to take precedence over the term, and with the terms expressly stated to be subordinate to them, then a dispute should more naturally be looked at as arising under the contract agreement, which does not provide the necessary arbitration support which the respondents need.
What I find slightly difficult about this is if, as you're putting very clearly, there are claims against parties, entities who are not a party to the specific product contracts.
Yes.
So you say they can't rely upon the terms of that contract and expressly so.
Yes.
But they are nevertheless being sued in Russia in relation to matters that arise from the relationship in broad terms between your client and JPM.
Yes, to which I would add, and in connection with the specific agreements.
Yes. Well, why does that not fall within the broad terms of the arbitration clause in the terms of business? They're being sued. They're not being sued under the contract, so that it's not a contractual claim, but it is a claim which is connected with their relationship with VTB, which seems to me falls within the terms of the broad terms of the arbitration clause.
Yes, but if the provisions within the specific contract include claims in connection with it, you look then to see, well, what rights does it give to those who are related parties who are being sued in connection with that contract?
And you say none.
And I say none.
It's irrelevant. It's irrelevant to them. That contract is irrelevant to them. The relevant contract is the terms of business.
Yes, but then one has to look at the terms of business a little carefully, because if the terms of business are not meant to cover, meant to be subject to the specific agreements, then why does it give some freestanding right? The terms are meant, in my submission, when you look at them carefully, to govern all the other relationships,
because these parties are not parties to another specific contract that's relevant.
Yeah.
So that issue doesn't arise because, as you say, they're not parties to it.
Well, they're not party to it, but what they're seeking to do here under the terms is what the terms are in connection, govern other contractual relationships between the parties and subsidiary related claims, whether tortious or contractual. There are no claims against these individuals to which those terms apply, because the only contractual or tortious basis for the claims is failure of their affiliate to perform under the specific contract. So we say that means that they can't rely on anything else. I mean, if you have terms to gather all the other bits, if we agree to do something else, we'll hold your money, we'll do this, we'll do that. That's not them relying on the terms as affecting them. It's say, because we've got this terms agreement, which is meant to cover all the bits and pieces, it means that if you sue us because of things done by your affiliate under the client agreement, then we can somehow use these terms agreement for an ulterior purpose, namely to provide a shield against being sued for those. But that's not what the terms is meant to be. The terms is not meant to
provide a shield, does it? It just simply says where any claims which are brought in connection with the relationship should be brought.
Well, if the terms agreement covered any claims in connection with the relationship in those broader terms, I can understand the point. But of course, what they actually cover, look back here to page 339. At 1.1, it says that it governs all designated investment business, blah, 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 any other service which is provided to or for you or transacted with or for you by any one or more of the following companies. Then
Which page are you looking at now?
page 339, clause 1.1. And it covers, terms of business cover lots of activities, designated investment business, which is provided to or for you or transact with or for you by any one of the following companies, JPMorgan Europe, etc. Each of these companies shall be severally and not jointly liable for their respective acts and omissions under these terms. So you can't say that because JPMorgan, one of the parties to the Account Agreement, is being attacked under or in relation to certain designated investment business and has a several liability in relation to it, that the terms somehow govern other tortious claims of the unusual nature now created by Russian law, because that's not in connection with the provision by the affiliates of those services.
But the arbitration clause goes wider, doesn't it? We look at page 357. We agree that any dispute, controversy or claim, including any contractual, pre-contractual, non-contractual rights, obligations or liabilities arising in any way out of or in relation to or in connection with our relationship. It's not just limited to contracts, it's the relationship.
But the relationship on which my clients bring a claim in Russia is not a claim in relation to the relationship with these other defendants. It is because of the other defendant's relationship with JPMorgan, which gives rise to a separate claim under Russian law. So it's not satisfactory to use this or these imposed terms, standard terms. They're bigger than Lord Denning's ones on the railway ticket, but nevertheless they're imposed terms sent with a notice.
How does that affect that? Surely all we've got to do is interpret them. You're not saying that they don't apply.
No.
So we interpret them. This is an agreement between two extremely large, sophisticated contractual entities, two banks,
yes,
which both understand how terms are imposed and are changed between them. How does any of that affect the interpretation?
It affects it because when you have a very carefully negotiated agreement like the Client Agreement or the Unallocated Metals Agreement, which the parties will have addressed their mind to carefully before agreeing it and signing it, then you don't expect that to be turned on its head.
But as you say, the parties we're concerned with here are not parties to that agreement.
No, they're not party to that agreement. But if that agreement, in its terms, excludes any right to rely on that agreement by the non-participating entities, then how is it that this kind of very broad standard terms suddenly give them a right to defend a claim in that way? I mean,
well, because you're suing them, not under the contract.
Yeah.
But undoubtedly by virtue of your relationship.
No, I'm suing them by reference to not my relationship with those defendants. I'm suing them by reference to those defendants' liability under Russian law.
But that liability surely depends on the relationship. between the liability, the entities you're suing, and JPMorgan entities with which you contracted?
It depends on the relationship between the JPMorgan entities. It does not rely on the relationship between my client and these affiliates, because there is none. But Lord, I've already made most of my submissions, and I was just trying to make it good.
Anyway,
like
you've
that. But
shown
let's
us
go back to-
what Lord Justice Hamblin said.
I'm sorry.
You've shown us what Lord Justice Hamblin said. Did you want to go to Clear Lake now?
Yeah, I did. And I think we can pick it up at page 318. And I'm taking it, your lordships are pretty familiar with this, so I'll take it at a gallop. He sets out a paragraph 18, the main legal principles which are not in dispute. Breach of jurisdiction clause in a contract between the parties. Well, we know there is a breach in relation to the contracting parties. The general rule is clear: where parties bind themselves by an exclusive jurisdiction clause, effect ought to be given to that obligation in the absence of strong reasons for departing from it. Whether a party can show strong reasons will depend on all the facts. That's the contractual basis. And then two, the second main ground is the foreign proceedings are otherwise vexatious or oppressive. Under this ground, it's necessary to be satisfied England is clearly the more appropriate forum for control of the action, sometimes referred to as a natural forum. It is necessary in the interest of justice to grant the injunction, taking into account considerations of comity. And we get Lord Justice Collins, who clarifies that taken together with other matters, the inherent weakness of a claim may here be an important factor. That's not alleged here. Not entirely clear what standard of proof needs to be satisfied in interim injunction. That's go on to paragraph 20. Legal principles may be regarded as well established and straightforward. A further aspect of the law, which is not so straightforward, there was the application of the relevant legal principles rather than the principles themselves that appeared to divide the parties. This is the extent to which an exclusive jurisdiction clause in the contract between A and B can be enforced by B against A by an anti-suit injunction so as to prevent tort proceedings against a third party. Assuming that subject to the third party point, the tort proceedings would otherwise be covered by the jurisdiction clause. So this is A in relation to Russia and B in relation to the other affiliates if I succeed on ground 3. Refers to a lot of the key cases. Put the specific issue in the broader context of general law of contract. The case of Snelling is well known as illustrating the general principle where there's a contract between A and B by which A promises B not to sue C. B as a contracting party may obtain a stay of proceedings to stop A proceeding against C. So where in the contract between my client and one of the JPMorgan entities is there a promise not to sue C? There isn't such a promise. We're talking about the affiliates, and the affiliates may rely on it, but there's no promise by my client not to sue them. Then we get quotations from Donahue and Armco. This is the speech of Lord Scott, which is in some cases doubted. And I think we can probably go to letter D. Commencement of the claim against two alleged tortfeasors elsewhere than in England would represent a breach of the clause. Defendant tortfeasor was a party to the agreement would, absent strong reasons, be entitled to an injunction restraining the continuance of the foreign proceedings, not only against himself but also against his co-defendant. the exclusive jurisdiction clause is expressed to cover any dispute which may arise out of or in connection with the agreement. It's not limited to any claim against the party to the agreement. So this is the arguments under the specific contracts which the learned judges found doesn't apply here. The non-party, if he remained alone as a defendant, would be entitled to claim a contribution, joint tortfeasor, position no different claim would be commenced in the foreign court with any of the tortfeasors not party to the exclusive jurisdiction clause of the defendant. Then we get wording 61. Injunction restraining the continuance of proceedings would not, of course, be granted unless the party seeking injunction, being someone entitled to the benefit of the clause, had a sufficient interest in obtaining the injunction. Well, that doesn't apply to Russia. It would, I think, be necessary for them to show if the claim being prosecuted in the foreign jurisdiction was one which, if succeeded, would involve them in some consequential liability. So these are all arguments where the contracting party can deal with it. He then deals with the specific facts of the case and says, entitled to an injunction that bars continuance of the claim, not only against himself, but also against Rossi and Stinson, with whom he's jointly and severally liable. So that is effectively the JPMorgan entities with the contractual rights seeking to bar the claim against Russia and the affiliates to the extent that they can't rely on the terms agreement. And then I think he goes on to quote from Mr. Rabinovitz. Gershi. And I think I can go on to paragraph 23 on page 322. In principle, and consistently with what Lord Scott and Lord Lawrence Rabinovitz said, I would express the correct approach to this question of whether a contracting party can enforce against the other contracting party an exclusive jurisdiction clause by an anti-suit injunction, so as to prevent tort proceedings by the other contracting party against a third party in the following way. It's a matter for the interpretation of the jurisdiction clause whether the clause extends to cover the tort proceedings against the third party. Applying the general law of contract, the correct approach to that question of interpretation requires the application of a modern contextual and objective approach. One must ask what the clause, viewed in the light of the whole contract, would mean to a reasonable person having all the background knowledge. And then the West Bromwich line of argument. And then 2, if as a matter of interpretation, the jurisdiction clause does extend to cover the tort proceedings against the third party, the contractual basis for an anti-suit injunction applies. So as regards an application by the contracting party, the injunction will be granted unless there are strong grounds. Well, if one looks at that and says, does the clause extend to cover tort proceedings against the third party? The learned judge has held that the clause within the product agreements doesn't, and the very words of the terms agreement, which provides that subject to the right of a party to rely on the terms agreement, the 99 Act does not apply. So the Russian subsidiary does not have anything which it can rely on, which covers the claim. Then 3, applying privilege of contract, only the contracting party, not the third party, can enforce the jurisdiction clause by an anti-suit injunction on the contractual basis. So the jurisdiction clause may be a relevant factor in granting the third party an anti-suit injunction on the alternative basis of foreign proceedings are vexatious or oppressive. It's also presumably possible in certain circumstances, the jurisdiction clause, even though not contractually enforceable by the contracting party in favour of the third party, may be a relevant factor in granting the contracting party an anti-suit injunction against the other contracting party on the basis of foreign proceedings vexatious or oppressive. And then goes on in 24, except Mr. Benevis in Gusol was correct that absent express words as to the jurisdiction clause extending to claims against non-parties, the starting point in interpreting a jurisdiction clause covering, let's say, all disputes arising out of that contract will be that only the parties to the contract are covered. They also agree with Lord Scott, where one has an alleged joint tort committed in relation to a contract by a contracting party and a non-contracting party. The objective interpretation of the jurisdiction clause covering all disputes arising out of a contract will tend to include a tort claim against a non-party, because this will help to prevent fragmentation. That's what he says. And then I think we can go to Renaissance Securities, which is in volume 2. And that's a tab 20. I think we can pick it up at AB 590. Where he concludes, paragraph 49, that the contractual basis for the ASI does not assist the appellant. Then we go to 591, paragraph 55. I see some false submission made by Mr. Lernstein to the appellant. Proceedings in Russia are vexatious and oppressive. Accepting present purposes, the claims are not in breach of the arbitration agreements. They do appear to be designed to circumvent and undermine the effect of those agreements. Accordingly, there seems to be 3 reasons in principle why this court should be prepared to contemplate granting an ASI in this case. 1, to protect the integrity of the arbitral process. 2, to protect the integrity of the orders made by courts in this jurisdiction. 3, to protect the public policy of the United Kingdom in having the sanctions regime which it does. I just want to pick up those 3 points because they're important. To protect the integrity of the arbitral process, well, if the arbitral process and the arbitration agreements provide that you can only sue by arbitration certain parties, but that does not include, in this case, and I'm going to call it, just use Russia because Russia is the one where there is no doubt about this. Why would it protect the integrity of the arbitral process to allow a claim against somebody who is not entitled to rely on the arbitration agreement for a separate alleged wrong. And it's not vicarious liability for the wrongs of the parties which can rely on the arbitration clause, where I would understand the point, but it's under Russian law for separate tortious liability of the Russian subsidiary. Why would that affect the integrity of the arbitral process? Secondly, to protect the integrity of the orders made by courts, well, that doesn't apply here. And three, to protect the public policy of the United Kingdom in having the sanctions regime which it does. Now, this is dangerous ground because each side, Russia and England, has a sanction regime which it imposes by way of public policy. And in my submission, to use public policy as a ground for requiring a non-party to the arbitration agreement to arbitrate pursuant to an arbitration agreement which is not party, if it wants any legitimate relief, is to impose an artificial barrier to the achievement of justice in Russia. And your Lordship will be only too familiar, as we all are, with the sanctions regime, which of course binds any party in relation to acts or omissions within England and Wales, but only applies outside England and Wales to UK persons, as they're defined, where it applies throughout the world. So sanctions don't apply to a Russian entity in Russia. The sanctions regime doesn't catch them. It's not relevant to them. The English law does not seek to impose its sanctions policy on Russian entities in Russia. And therefore, permitting a Russian entity to sue a Russian entity in Russia under Russian law does not in any way impinge on the public policy of the United Kingdom. If the United Kingdom policy extended to acts done by any party in any jurisdiction, I would understand it, but it doesn't. Then paragraph 58, I also bear in mind what the judge said in paragraph 22. On the basis of this material, I accept Renaissance's submission to lictual claims by the defendants against the RREs are claims to recover damages in a sum equivalent to what is alleged to be the value of the assets that have been frozen by Renaissance. I accept the claims have been brought in Russia because the defendants are precluded from recovering their assets from Renaissance other than LCI arbitration proceedings against Renaissance in London, which the defendants would have to prove their case that would not properly be regarded as subject to any relevant sanction. So they would fall within the uncontemplated fetters of the 2022 sanctions law. And then he refers to Judge Pelling in Barclays Bank. It might have been said on behalf of the defendants or Solcom Bank at any rate that commencing proceedings in England deprives them of a legitimate juridical advantage, because the Russian courts will disregard as a matter of public policy the sanctions law imposed by English law. Yes, if and to the extent that as relied upon, in my judgment, its proposition to be rejected, the parties having agreed English law to attempt to litigate in a foreign jurisdiction where full effect is not given to English law, including therefore sanctions law, is not to seek to obtain legitimate juridical advantage. On the contrary, to seek and obtain an illegitimate juridical advantage. It's been recognised in the case law as a reason for treating a claim brought in such a jurisdiction as vexatious and oppressive. So, just pausing there. The parties having agreed English law to attempt to litigate in a foreign jurisdiction is vexatious and oppressive. The parties here, VTB and JPMorgan Russia, and any of the other entities which can't rely on the terms agreement, have not agreed English law. Other entities who are under the terms agreement, severally but not jointly liable, have agreed certain restrictions on their ability to bring proceedings, but the Russian entity hasn't. So, in my submission, one has
Has it not under the terms of business?
I'm sorry?
Has it not under the terms of business, whether or not it can rely on the arbitration clause in those terms or in the product contracts? Has it not agreed that the relationship is going to be governed by English law?
No, for two reasons. First of all, there's only one additional party, which is party to the terms agreement in its terms. Secondly, the application of those terms to affiliates is not in terms, this will bind affiliates, or this applies to affiliates. It entitles affiliates to rely on it on the same basis as if they were a party to the terms. So, that applies to the non-Russian entities, subject to the arguments I've made already, which I won't repeat. But the Russian entities, which would have been entitled to rely on it, and if they had relied on it, then we'd have had to deal with it, have expressly not relied on it. It is JPMorgan who's saying that effectively, well, Russia would have been able to rely on this, but they haven't. So you should give them the benefit of the clauses to which they're not a party and on which they haven't sought to rely, because that might give VTB a cause of action which it can enforce in Russia, not outside Russia, because you can't enforce it in England because of sanctions legislation. So why should we be prevented from suing JPMorgan Russia under this analysis? And the answer is there is no reason under this analysis, because they are not parties to or seeking to rely on the additional support given to them by the terms agreement. Now, if we get back to the judgment, please, page 10.
The judge's judgment in this case.
In this case, yes.
Yeah.
Paragraph 151 on page 103. And this is his conclusion. I'm satisfied the commencement of pursuit of both of these claims is vexatious and oppressive, subject to issues gained to the court's discretion more generally, which I addressed below, should be restrained by anti-suit relief. You consider the claims asserted in the two agreements, UMA and client agreement claims, as a matter of substance, categorize them as a matter of English law by analogy with the cases referred to above. So analyze their attempts to recover amounts said to be due under contracts governed by English law. In their substance, the Russian law tort claims are an attempt to enforce inherently contractual obligations in an inherently contractual way. Well, with great respect to the learned judge, as he'd already found earlier, these are tort claims brought in Russia for tortious liability against individuals not relying on any contractual framework. Now, and if one asks, what are the contractual obligations which my client seeks to rely on in relation to JPMorgan Russia. Well, as I was at pains to point out to the learned judge, these are claims for a sum of money which is held, or an amount of silver and gold, which is held by JPMorgan totally outside the contractual arrangements. I mean, it would make no difference as to whether the money was frozen when it was still being traded, when it was sitting in a bank account, when it was on its way through a correspondent bank account back to Russia, or otherwise. The claim is not for breach of the agreements. The claim is for, yes, you performed the agreement, yes, you've told us we're entitled to 88 million and 70 odd million worth of gold and silver. Can we please have it?
That's a claim in debt, isn't it, in an ordinary banking situation?
Yes. It's
Well,
not
that's
a contractual
contract.
claim.
It's a claim in debt.
Yes. If they say, well, we've accounted for it by putting it in a frozen account, which is what sanctions requires us to, it's a claim for money hadn't received, but it's a claim for the recovery of money. It's not a claim for breach of a contract. So to characterize it as being a contractual entitlement, they could say, we've done this. We've actually...
Surely it is a contractual entitlement. I open a bank account and I deposit money in it. The money belongs to the bank, but the bank owes me a debt equivalent to the money I put in the bank.
Yes.
That's a contractual claim,
Yes.
surely.
It is. But it applies when you get to the stage where, and I was looking at something in a completely different context yesterday, in a different jurisdiction, you have money and the bank does everything it can to comply with its contractual obligations. It arrives in a correspondent bank in, let's keep it in England and Wales, in London, and it's frozen there. The claim by JPMorgan Russia is that JPMorgan has not given us our money. That gives you, JPMorgan Russia, a tortious liability. Now, the fact that it looks a bit like a contractual liability under English law being imposed upon a counterparty doesn't work when the claim is against the actual tortious liability of the individual. And in my submission, to say that you treat this as if it was a contractual claim in an inherently contractual way, really says, well, English law would regard it like that. The fact that Russian law doesn't is neither here nor there. And in my submission, that's not enough as a ground for saying that it is vexatious for my clients to rely on properly introduced Russian law, that is law of a, I'm going to call it a non-unfriendly nation for these purposes, because that perhaps accurately summarizes what the legal position is. They're not characterized as an unfriendly nation. The laws of comity requires due respect to be given to their legislation, except to the extent that English sanctions law prevents it. And I accept...
Due and mutual respect?
Sorry?
Due and mutual respect?
Mutual respect, yes. Of course I do, because each party must respect it. And if we're entitled under English law, or even under Russian law, to the return of our money, absent sanctions legislation, the fact that we've imposed sanctions legislation on money in England, and they've imposed in Russia, if you like, a prohibition on any defense which relies on Western sanctions, doesn't affect the position where there is money in Russia. Now, I entirely accept that if I was trying to use this as a vehicle to obtain money in England, then that's court because it would be an act done in England by anybody. But what I'm trying to do is to enforce a legal right under legal Russian provisions in Russia against a Russian entity for monies which are in Russia, so that we can enforce it within the Russian Federation. And that is different, and in my submission, it wasn't affected by sanctions regulations. Sanctions regulations are intended to prevent acts in England by non-English persons, and anywhere in the world by English persons. If I tried to sue the English JPMorgan, there isn't one actually, it's a US one, but US sanctions are sufficiently similar, it doesn't matter, by requiring them to pay money, then that would be trying to circumvent English sanctions law. But here it's not. I'm trying to enforce it in Russia. In the same
Can I
way,
just ask about just about the analysis for a moment? I think, as my lord put to you, we're not talking here about pots of money sitting in some vault.
Yeah.
These are contractual debts, basic banking law,
yes,
and they're governed by English law.
yes.
And the current state of English law, because of the sanctions, is that in fact those debts are not payable.
Those debts cannot be released if held in England.
Well, they are debts owed subject to English law, and the current state of English law is that those debts are not payable. Is that right?
Not quite, my lord. Under English sanction law, any such monies must be frozen, first of all.
Yes, that means they can't be paid.
Yeah, but we're not talking about a pot of money. We're talking about rights to money and rights to equivalent amounts of precious metals. They can't be paid over from England. They can't be paid over by a UK person. But that's as far as the sanctions go. The sanctions do not say, and there's quite a lot of misunderstanding because the courts haven't yet got there, although they soon will be getting there, to the question of whether or not there is some form of permitted expropriation because there's no interest on money. But the fact here is that we are asking for the right to claim from a Russian company its own money equivalent to that which would, but for sanctions, have been paid over by JPMorgan entities outside Russia. Now, it's not a prohibition on...
Let's suppose that you succeed in that.
I'm sorry?
Let's suppose that you succeed in that. You
Yes.
get your order in Russia against the Russian company,
Yes.
and you get the amount equivalent to what the other entities hold.
Yes.
Does that discharge the debt?
No, it discharges the liability of JPMorgan Russia to pay under Russian law.
Does it discharge the debt?
I think because it's not being paid by the obligor, it may not. What it would do is to provide a complete defence to any action brought on the debt in this jurisdiction.
Why?
It might even, it would also give a right to one of the other JPMorgan entities, subject to the arbitration clause, to bring arbitration proceedings, and under those arbitration proceedings, to seek orders in relation to those monies. But I'm hesitating on your Lordship's question because, of course, the result is a mixture of Russian law and English law. Under Russian law, it is discharge of the liabilities. Is that sufficient to discharge the debt where the money comes from a third party? Not under the law of debt, I think, but it certainly would prevent a further claim being brought within this jurisdiction. So I want to come to what learned judge says next as paragraph 151. 2. I'm satisfied the pursuit of these claims is intended to circumvent the arbitration agreement, the rule of English law which would apply more generally the English law sanctions regime. In doing so, VTB seeking to obtain illegitimate juridical advantage, namely avoiding the laws of England and Wales, is undermining the efficacy of that regime. And I made the point before, Judge Leeds, it either is a breach of sanctions regime or not, and I've just shown your lordship how it's not a breach of the sanctions regime if paid by a Russian entity in Russia. I accept such a circumvention is a relevant factor which forms part of the overall assessment whether a claim is vexatious and oppressive. The ability to take factors into account without making it definitive benefits approaching the issue on the basis of vexatious and oppressive jurisdiction. Then the provisions of Russian law used to impose liability on non-parties do not accord with generally recognized principles of civil law. For that, with respect, is a value judgment on a question of third-party and subsidiary liability under Russian law. And it is no more at odds with some kind of universal, generally recognized principle of civil law than some of the English law rules on attribution of knowledge and vicarious liabilities, which are not accepted in many civil law contexts. Then claims in tort for failure to pay a debt, a tortious obligation imposed on all companies in the same corporate group, regardless of any involvement in the transaction, to take steps to require a debtor to pay, are an unnatural form of liability as a matter of general principle of civil law. Well, again, with respect, if a legal system passes valid laws which can impose liability on a sister company for the wrongs of another, then in my submission, it can't be dismissed as being an unnatural law. And then he mentions the Russian legal principle developed in response to sanctions is to purport to make a significant retrospective change to English law obligations, in particular to the identity of the parties to those obligations. Also as the second matter. Well, again, here I'm talking about claims against the Russian entity in Russia, not subject to the arbitration clause and not subject to English law because they're not parties to any English law contract. And that, he says, is a sufficient interest. And then he comes to the conclusion that they're vexatious and oppressive. Let me just look at this a bit more slowly. Both in regards to JPM PLC and JPM CB, also as regards the other JPM entities joined to them. In particular, it's vexatious and oppressive to JPMS PLC, JPM CB, to pursue an affiliate such as JPM Russia. In the circumstances outlined, bring what are in substance claims for enforced obligations arising under agreements to which their parties, otherwise than in accordance with applicable law and dispute resolution provision as a method of circumventing sanctions. With great respect to the learned judge, that all depends on whether you regard Russian law as being law to which principles of comity require there to be recognition and respect, or simply say, well, we don't agree with English law, doesn't agree with English law or sanctions, and therefore, as far as we're concerned, it is to be ignored. the court has to proceed from the basis that these are valid Russian claims, properly brought in Russia against a Russian entity to which sanctions law does not apply. And the effect of the injunction against JPMorgan, Russia, is to subvert the rights of my clients under Russian law in a Russian-centric claim, which is the liability of a Russian entity for wrongs done by an affiliate. And in my submission to say that that is vexatious and gives them a sufficient interest is too short. So where do we go from there? And I don't need to take the timings point. I can go back to my scope and argument. So if we pick it up at the bottom of page 36, internal page 13, paragraph 36.
Sorry, where are you now, Mr. Fenwick?
I'm in my skeleton.
Your skeleton.
You're visiting it briefly. Page 36 of the core bundle, paragraph 37. We don't contest the judge correctly set out the law, covers all that.
Just before we get into the detail, what is the test that an appeal court should apply to the kind of evaluation which the judge undertook?
An appeal court should respect the evaluation, but to the extent that the evaluation is based on wrong principles or a wrong application of those principles, then this court should interfere with it.
So are we effectively applying the sort of test in Sprint Room?
Yes. And it's particularly relevant in my submission where the judge himself recognised that there wasn't sufficiently clear guidance, and therefore that, if you like, this is what I think, but the Court of Appeal may say that I'm wrong, or hopefully they'll say I'm right, and we shall have to see. So we just pick up the points I've been looking at on the top of page 37. Comment, telling against interference with the process of a foreign court will always require careful consideration. Well, that's completely right. And what I've sought to do by going through the judgment is to identify the fact that the judge has really focused on the extent to which the claims in Russia are inimical to English concepts of contractual and tortious law and liability, as opposed to is this clearly, obviously, or at least strongly arguably, a lawful application of lawfully introduced laws of a non-unfriendly nation, which is about as high as I could put Russia just at the moment. And whilst I quite accept that the court might conclude that sidestepping contractual provisions which protect a contracting party or expressly protect their affiliates, and I've made my submissions as to that, may be a good reason to, where you have an English law, English jurisdiction, English arbitration, provision may be a reason why comity does not require the English court to give weight or much weight to the Russian proceedings and the Russian court's process. But where we're dealing with somebody who is a stranger to those contracts, a stranger to the protections of the arbitration clauses, in my submission, one must give proper respect to the processes of that foreign court in the same way as one would expect if your lordships were Russian judges sitting in Moscow, that you would give a careful respect to the provisions of an English court. And it's only if paying respect by reasons of comity to a foreign court, in this case Russia, would represent a breach or circumvention of sanctions, or would be an illegitimate circumvention of arbitration proceedings. And I've made the point by reference to JPM Russia. Then in my submission, reasons of comity suggest that your lordship should say that JPMorgan Russia should be left to Russian law, Russian jurisdiction, not based on the arbitration clauses, but based on the liability of that Russian subsidiary, JPMorgan Russia, for.
So does your argument focus entirely on JPM Russia? What about the other entities?
Look, it focuses on JPM Russia because they're not party to anything.
No, I understand. I understood that argument. But what, if anything, are you saying about the other JPM entities?
What I'm saying about the other entities is that if your lordship, for those who are contractual parties, I don't make the point. For those who are non-contractual parties, it will depend upon my submissions on ground 3, and if they fail, they're in the same bucket. But when looking at them, it's in my submission wrong to say, well, because if you wanted to get the money from one of the contracting entities, you'd have to use an English arbitration. You can't get a different remedy, albeit for related subject matter, out of the Russian one. So you can't use the contractual right as a bootstrap to bring a vexatious argument. I mean, if you've got a contractual right, you've got a contractual right. If you haven't got a contractual right, say, well, and this is really a key point, where there's no contractual right, you can't say, but it's vexatious, so we won't allow it. Well, if there's a contractual right of my client to bring these claims where they want to, there is a contractual right. And this court should not ignore the comity which it owes to the Russian court, which has jurisdiction over them, by doing it. So in my view, it's a bit of a distraction to look at it and say, well, they've got contractual rights which are going to be subverted. They're not. If a party is not entitled to the contractual protections, then the contractual protections are irrelevant. And you can't get a party which has a contractual rights saying, well, my mate, JPM Russia, doesn't have those rights, but because I've got them, it would be an abuse process and vexatious to allow them to be sued in accordance with Russian law in Russia. So it centres on the position of JPM Russia and anybody else I succeed on in round 3, but I don't accept that there is a proper ground for using the oppressive and vexatious approach
Yeah,
to
I'm wondering where this takes us in terms of the orders that the judge actually made. In your appellant's notice, you page 11 of our bundle, in the section, what are you asking the appeal court to do? You just tick the box, set aside the order. But on the basis of your submission so far, there are quite large parts of the order that you don't actually challenge. And JPM Russia, if I've understood correctly, was originally the fourth claimant and no longer pursued its claim.
yes.
So where does this get us in terms of the orders that the judge actually made?
If your Lordship looks at page 53 of the bundle within the first order,
53, yeah?
paragraph 4,
Yeah.
commencement pursuit of the client agreement claim, not the ISDA claim, constituted breaches of the defendant of the arbitration agreement are concerned with claim against the first claimant. Commence of the client agreement and ISDA agreement constitute a breach of the terms of arbitration agreement as far as concerns the claims against second to third, fifth to ninth.
Right, so that omits the fourth.
I'm sorry?
That omits the
It
fourth
omits
defendant,
the
that is to
fourth.
say JPM Russia.
Yes. Paragraph 5 says the commencement and pursuit of the client agreement claim is to claim against claimants and Russia,
That's JPMBI.
JPMBI, is vexatious and oppressive.
Right.
And then final injunctive relief, which prevents us from taking any steps, 6.1, to prosecute or progress its claims against the claimants and JPMB Russia in the client agreement claim or the ISDA claim, and from commencing or pursuing or prosecuting or progress of any other proceeding in any court or tribunal, in any dispute arising out of or in connection with the client agreement terms of business, otherwise than through LCI arbitration seated in London.
Yeah.
So that, because the learned judge has found that the claims being made were made in connection with the client agreement and the Unallocated Metals Agreement, it prevents us bringing the claim against everybody, including JPMBI Russia.
So is what you're actually asking us to do simply to remove the words and JPMBI from the order?
If I fail on my ground 3,
Yes.
I'm asking the court at this stage, as one further point I have to come to, which is ground 4, to remove Russia from the order.
Yeah.
So I have just right? Yeah, I'm back to my skeleton, page 37 of the core bundle. And those principles he set out, sufficient interest, and so on. And 38, we say no definitive criteria for the court to determine whether or not the conduct of the litigant overseas is vexatious and oppressive. He was correct to identify great caution must be exercised before granting an injunction. Then over the page, we say he demonstrated no careful or cautious consideration of comity at all. I've made my submissions on that. His assessment referring to all the factors. But the factors, we may need to look back at 151 of the judgment for this. That's at page 103. And you see what the judge said at 151. One, he's recategorizing them as English law claims, and Russian law tort claims an attempt to enforce inherently contractual obligations. I said what I said about that. Tended to subvert the agreement, dealt with that. General principles of English civil law under 3 I've dealt with. The effect of the Russian legal principles developed in response to sanctions is to purport to make a significant retrospective change to English law obligations. Yes, perhaps, but here we're talking about Russia and Russian law where sanctions don't apply. And that establishes a sufficient interest for the purpose of granting anti-suit relief. And then he says it's vexatious and oppressive to pursue an affiliate such as JPM Russia. Now, in that, with great respect to the learned judge, he starts from the premise that here we are with English law. He accepts that Russian law is different, but he doesn't seek to say that it is law which the English courts should give no respect to at all. He simply says English law is different. And then he says, well, what this amounts to is a way of getting round the sanctions provisions. Well, if there is a legitimate claim against an entity which is not bound by sanctions, that is to say, it is not a claim against a UK person.
I think you've made this point several times, Mr. Fennick. You say it's a claim in Russia brought under Russian law against a Russian entity with assets in Russia, which is not subject to the UK sanctions regime, and I think we've understood that point.
I'm not saying that's it, but that is the comity argument. When you then have to consider whether there is a sufficient interest, and again I'm going to address here the non-contractual entities, and in particular Russia, I say that why is there a sufficient interest in preventing that Russian claim, which I won't repeat all the nuances to. And so we say that the court should not find that there was sufficient interest, having regard to comity, to exclude claims or prohibit claims against JPMorgan Russia. And I just want to say one thing about the question of guidance, which Ms. Justice Foxton referred to. What one sees here is very little in the authorities about actually how you establish what is a sufficient interest and how it relates to comity. And in my submission, comity is at the beginning. We put out the references to that. It's to be given real weight, and you only override that weight which is to be given to the courts of a non-unfriendly nation, where there are very strong reasons, not just, it seems a bit unfair that they can get round the provisions, particularly where everything relied on is not, if this was a claim, you are in breach of the client agreement because you sold for too little, or you're in breach of the Unallocated Metals Agreement because you flogged metals when they were at the top of the market against our instructions. That's all clearly stuff which should be litigated or arbitrated in accordance with the jurisdiction and forum agreements within the contract. When it comes to this is in connection with, because it's a claim for money afterwards, which has been blocked by sanctions, then that is not sufficient to make a sufficient interest. And I invite your lordships so to find and to give guidance in relation to that, which says that you must respect comity, and the sufficient interest must be sufficient to override comity, and you must do so expressly and for clear reasons. So I want to come lastly to my ground four.
Just before we go to ground four,
Yes.
not being an habitué of the commercial court, I don't have the Russian legislation at my fingertips in the way that all you do. Do we have it somewhere? Not in Russian, obviously, but do we have it, or a summary of it somewhere?
It was below. I'm not sure that it. What is it? The court can be provided with it.
I think it might be useful just to,
Yes.
to see what it actually says.
I looked for it when I was preparing this, and I thought, well, perhaps we don't need to look at it, but it was in the evidence below, so your lordships can be given it during the course of today.
Right. All right. So ground four.
Ground four, and the point here will depend on whether, I mean, if you don't find for me at all on grounds 1 and 2, then cadit quaestio.
Yes.
If you do find for me in relation to one or more of the entities, then the question of the court's discretion arises. And if you find that I win on the affiliates point, that means there will be claims proceeding in Russia in any event. And for the reasons we set out in our skeleton, Russian persons, Russian witnesses, Russian law, it is appropriate that the claims should be dealt with in Russia.
Yeah.
I accept that if I only have the Russian subsidiary, my argument was saying, because I've got the Russian subsidiary, because it's not a party to this, you should drag all the other parties, which do have the benefit of the arbitration clause, into Russia against the provisions of the arbitration clause, is rather weaker. And I'm not going to make any additional submissions in that circumstance. So if I win on Russia only, then I can understand that the court will consider ground 4. But the arguments may land in favour of allowing the other claims to be barred. So I'll have to bring them in arbitration in this jurisdiction, which, if we're forced to, we will have to. This is not a case of we've only got one shot, which is Russia. It is a case for, if we have to do it that way, then we will have to do it. But we shouldn't be obliged to, for the reasons I've identified. And of course, we know that if I win in the arbitration, I won't get any money anyway. These sanctions are intended to be a temporary, non-permanent, non-expropriation. Good luck to that. This court is beginning to approach them in its judgments as being, although intended to be temporary, likely to last for a very long time. And so we are effectively talking about two things. One, we're talking about long-term deprivation of the property rights and contractual rights of my clients. And we're of course talking about exposing them to the expropriation, which is becoming a fashionable aspiration of politicians in the EU and apparently in this jurisdiction, which it shouldn't be, because my client is, on any view, entitled to this money. It may not be entitled to get it yet because of sanctions. If English law applies, it will be if Russian law applies in Russia. The court should take that into account. And in those circumstances, if you find that a significant number of the defendants are liable to be sued in Russia and cannot rely on the arbitration clause, there is a strong case for a single forum. If there is one, the case is weaker. Lords, I was always a little concerned about the pessimism of the time estimate, which
Well, we had 2-day time estimate.
the court imposed it. What happened was we said 1 day, learned friend said a day and a half, and the court said we'll have 2 days.
Right. All right. Well, congratulations. We're getting through it quickly.
Well, look, there's no point repeating things. They don't get
No.
better, but equally they don't get worse. They might be more irritating.
Right.
Unless I can assist you further, those are my submissions.
Yes, thank you very much. Mr. Jones, do you want to add anything?
No.
We'll rise for a couple of minutes to see where we go from here. Don't leave the courtroom.
Well, I'll be surprised if we do go to tomorrow then. Which is of some significance to me since I flew back from Cambridge at the weekend. I'm in the middle of a trial.
We needn't trouble you, Miss Hutton. The appeal will be dismissed for reasons to be given in writing later, and the drafts will be sent out electronically, subject to the strict embargo. That's your opportunity to correct our English, but not to re-argue points or introduce new ones. We would hope that in the light of the drafts you will be able to agree in order disposing of the appeal. If you can't agree in order, please make short written submissions and we will make the order that we consider to be appropriate. The judgment will eventually be handed down electronically by distribution to the parties and released to the National Archives. We would appreciate, in the meantime, the summary of the Russian law applicable, and it may be helpful to have some indication of the sanctions regime as well. Thank you all very much.
The Russian sanctions regime.
I'm sorry?
The Russian sanctions regime.
No, the English one,
English one, certainly.
which we again haven't got in the bundles. Thank you all very much.